So, pupunta na po tayo sa next topic. Land titles, no? Land titles po. So, to give a brief introduction to the next speaker, he is a senior partner of Samarita, Manaloto, and Santiago Law Offices, formerly senior associate at the law firm Pelaez, Gregorio and Gregorio N. Lim, served as legal counsel, director, and corporate secretary of various corporations and foundations, more than 12 years in the practice of law, presently serving the Lord as corporate secretary and legal counsel of CCF and of CCF Life Academy. He is leading a D12 group, the discipleship head of Law Ministry, happily married to his wife with 2 wonderful sons. Please welcome Attorney Robert Samarita.
Now, our outline this morning is simply as this: I-mark, I-M-A-R-K. Markahan po natin yung ating land titles. I-mark stands for the following. First, we'll have I as identity, our identity in relation to land. M, the mode of conveyance or yung mode of transfer if we have possession or rights over land. A is avoidance of error in land transaction. And R, in the event that we become a victim of any fraudulent transaction in relation to land, what are the remedies available to us? The last point in our outline is K, knowing the best possession. Knowing the best possession. So let's start with I. Our identity in relation to land. All of us here, meron tayong connection sa land eh. In any of the following possibilities. First, we can be the landowner or the tenant over that land. In a transaction involving land, for instance, if it is a sale, then our relationship is either we are a vendor or a vendee. Third possibility is either we are a mortgagor or a mortgagee. Pag sinangla po natin, for example, yung lupa sa bangko, we become the mortgagor and yung bangko ang naging mortgagee. We are either a lessor or a lessee, nangungupahan or nagpapaupa. Next possibility, either we are the trustor, tayo yung may-ari, tapos pinagkatiwalaan natin sa iba, or a trustee, tayo yung pinagkatiwalaan na mag-manage ng lupa. And then, if it involves a donation or binigyan tayo ng regalo, pag tayo ang naging recipient ng regalo, tinatawag doon ay donee. Pag tayo naman nabigay ng lupa sa iba, we are called the donor. Now, kung hindi tayo landowner, vendor, mortgagor, lessor, trustor, donor, tenant, vendee, mortgagee, lessee, trustee, or donee, pero we are in possession of the land, nagpatayo tayo ng structure, pinaupahan natin yung structure, pero hindi tayo may-ari, wala tayong title, anong tawag sa atin or tawag sa akin? Squatter. Anyway, so in any of these connections with the land, you are either a landowner or any of the other persons as described there. Now, in the Philippines, sino po ba ang pwedeng magmay-ari ng lupa? Lahat ba pwedeng magmay-ari ng lupa? For example, yung bang let's say nag-asawa tayo ng foreigner. Yung asawa ba nating, example, mayaman na foreigner, pwede ba siyang bumili ng lupa at ipangalan yung titulo sa kanya? Ito po yung no daw, hindi pwede. So wag ka na lang mag-asawa ng foreigner para pwede ka mag-ari ng lupa. Mas maganda yung mayamang may foreigner, hindi siya may-ari, ako na lang mag-may-ari. Mas okay. Di ba, ma'am? Now, who can own? Sino po ang pwede mag-may-ari? Number 1, ito po yung general rule. Only Filipino citizens, including Philippine corporations, sila po yung pwedeng mag-may-ari ng lupa. Pag corporation, ano yung requirement? Dapat at least 60% ng authorized capital stock ng korporasyon will be owned by the Filipinos. If it is lower than that, hindi po pwede. Next, an heir can also own the land in the Philippines. Acquisition by hereditary succession being the legal heir. Paano po kung foreigner? Let's say may anak kayo, tapos pinanganak siya sa US. So kahit Filipino citizen kayo, pag pinanganak sa US, automatically by operation ng US law, the son or the child is automatically a US citizen. Paano kung US citizen yung anak nyo? Pwede ba siya magmana sa Philippine? Do sa general rule, dapat Filipino citizen lang. Pwede po pagka by way of hereditary succession. Pag minana or mamanahin pwedeng magmay-ari yung foreigner. Third, former natural-born citizen of the Philippines who became a citizen of another country but is now returning to the Philippines to reside permanently, subject to the limitations. So, kung dati, yung natural-born citizen po ng Philippines, ibig sabihin, yung dito pinanganak, parents niya, no, not necessarily pa yung dito pinanganak kasi hindi yun yung rule natin. Sa atin is pagka yung parents mo, one or both, Filipino, automatically, you are a Filipino citizen. Yun yung present rule. 1935, kailangan mo pang mag-elect pag isa sa parents mo, Filipino, isa foreigner, upon reaching the age of 18, you have to elect. You have to choose kung Filipino citizen ka or a foreign nationality yung kukunin mo, i-elect mo. And then fourth, Filipina who marries a foreigner but retains her Philippine citizenship can acquire and own land. So Filipina, nag-asawa ng foreigner, pero hindi siya nagpalit ng citizenship, pwede siyang mag-own ng land. And then the last one, property is acquired prior to the effectivity of the 1935 Constitution. Prior to 1935 po, pwede yung foreigner pang like yung mga Americans before, they were allowed to own lands. Okay, so ito po yung mga pwedeng mag-own ng lupa sa Pilipinas. Now, question, can a foreigner married to a Filipino citizen own land in our country? Foreigner yung lalaki na pangasawa yung Filipinang babae, pwede bang mag-own yung foreigner? Let's take, para maging actual example, yung kay Ma'am Shimamoto. Si Ma'am married a Japanese, Mr. Shimamoto. Now, can Ma'am Shimamoto still own land in the Philippines? Married na siya to, Ma'am, your citizenship is still Filipino citizen. Filipino. Pwede ba si Ma'am mag-ari ng lupa sa Pilipinas? Yes. But what about her husband, si Mr. Shimamoto? Pwede ba siya mag-own? O what if ganito ang ginawa? Punta siya sa Pilipinas, tapos sabi niya, what's your first name, ma'am? Is it okay to use your name? Bing. Yeah, Miss Bing. Sabi ni Mr. Shimamoto, Bing, bili tayo ng lupa dyan sa tabi ng CCF, Valle Verde. Okay, so they bought one parcel of land sa Valle Verde. Lot 1, Bougainvillea Street, Valle Verde 1 sa Piña Road, malapit lang sila. Tapos pinarehistro nila, TCT number 1 registered in the name of Mr. and Mrs. Shimamoto. Valid ba na half of that property, sabihin ni Mr. Shimamoto, sa akin yon? Kalahati lang kay Bing. No, because Shimamoto cannot own. Sabi, Bing, sobra namang higpit ng batas sa inyo, ganito na lang po. Ikaw ang bibili ng lupa, I'll give you 30 million, register mo sa name mo, pero ako talaga may-ari niyan kasi galing sa aking lapad ang pera na yan. Ilang dugo ng lapad ang binuhos ko para makuha mo yan. So, bumili ng property sa Valle Verde, registered in the name of Bing, pero kay Mr. Shimamoto talaga yung pera. Hindi sila nagkaintindihan, ayaw ni Mr. Shimamoto, are you from CCF, ma'am? Yeah. Sabi ni Shimamoto, I don't like to attend the CCF. Only you, go there. Tapos sabi nila, ayaw mo? Hiwalay na tayo. God forbid, example lang po ito. They decide, sige, hiwalay na tayo. Tapos sabi ni Shimamoto, okay, hatiin natin ang property. Mr. Shimamoto filed the case in court. Sabi niya, bawiin ko yung pinambili sa Valle Verde. Can Mr. Shimamoto be allowed? No. So this is an actual case of Helmut Müller and Elena Müller, French. German pala, sorry. Helmut and Elena got married in Germany. They bought a house and lot in Antipolo and was registered in the name of Elena only. So mag-asawa in Germany, tapos German yung husband, bumili ng property dito sa Antipolo, tapos pinarehistro lang sa pangalan ni Elena, ng wife. Because they're aware na bawal yung foreigner na mag-own. Later on, they separated and Helmut filed a petition for dissolution of property, dissolving property, and asked for reimbursement of the funds he paid for the land. Kasi nanggaling yung pera kay Helmut. Anong sabi ng court? Pwede bang ibalik kay German yung perang pinambili ng lupa? Sabi po ng korte, Müller, being a foreigner, was prohibited from owning a parcel of land. So, bawal siyang magmay-ari ng parcel of land in the Philippines as he had in fact the Antipolo property titled in the name of his wife. So, alam naman niyang bawal, kaya nga pinangalan niya sa wife niya. Tapos sabi ng court, to allow reimbursement, in effect, will permit Müller to enjoy the fruits which he is not allowed to own. Not even ownership in trust is allowed. So kahit pera niya yon, bawal kasi ng ikaw magmay-ari ng lupa, hindi pinayagan ng korte na bawiin yung pinagbentahan o yung proceeds ng value ng lupa. So in effect, yung pera napunta talaga kay Filipina. Kasi sabi ng court, even ownership in trust, hindi allowed. So if you're going to marry a foreigner and you want to buy a property in the Philippines, buy and buy more properties. Even if it is registered in his or her name. Because ultimately, the ownership will be yours. Now, can a naturalized Filipino citizen inherit the land purchased by this foreigner parent? Ito naman po, yung situation is, meron kang magulang, let's say Chinese, yung parents mo, tapos nakabili siya ng lupa na Chinese citizen pa siya. Nung pinanganak ka, Chinese ka, pero nagpa-naturalized ka na. So ngayon, naturalized Filipino citizen ka na. Namatay si father mong Chinese, nagmana ka ngayon. Yung nalaman nung nagbenta sa tatay mo na, bawal pala, nag-attend ako ng lecture sa CCF, bawal pala, mali palang ginawa ko. Tapos pwede ko bawiin. So nag-file siya ngayon ng kaso against you. Uy, akin yung lupa niyan kasi mali yung benta sa tatay mo. Hindi pala pwede yon. Ay ngayon sabi mo, hindi, Filipino na ako. Pero galing yan sa foreigner na parent mo. Pwede hubang recover pa yon, ma-recover. Nasa ako na, anak na naturalized na. Ang hula po natin is yes or no? No or yes. We'll find out. Ito po yung situation. Si Tantay, Chinese national, bought a parcel of land in the Philippines. After he died, the lot was transferred to his son Joaquin, a naturalized Filipino citizen. So nung nabenta po, kay Tantay, Chinese siya. Namatay si Tantay, minana ng anak niya na si Joaquin. The seller, yung nagbenta, filed an action to annul the sale para ipawalang bisa po ang bentahan. Kasi nga, that's prohibited sa batas natin. Hindi ka pwedeng ibenta sa foreigner at yung foreigner hindi pwedeng magmay-ari ng lupa. Ang ruling po ng court, sabi ng court, while the vendee was an alien at the time of the sale, the land since become the property of the son, Joaquin, a naturalized Filipino citizen. Hence, there would be no more public policy to be served in allowing petitioner to recover the land as it is already in the hands of the qualified person. So, kasi ngayon po, ang situation na kay Joaquin na, pwede na magmay-ari si Joaquin kasi naturalized Filipino citizen. Magiging different po ang situation at ruling kung nung nag-file siya ng kaso to annul para ipawalang bisa yung sale, kung final niya yun nung buhay pa si Tantay. Sigurado ho na kung nung buhay pa si Tantay, pwedeng ma-revert yung reversion, ibabalik yung pag-aari ng lupa dun sa seller. The situation is different now because Joaquin is a naturalized Filipino citizen na. So, ito po yung rule natin with respect to ownership of land involving foreigners and Filipino citizens. Let's move on to the next point. Letter M, mode of conveyance or transfer. Ano po ba yung different ways of transferring land? Gusto mong ilipat yung pagmamayari mo ng lupa sa ibang tao. These are the different ways. Number one is by sale, voluntary or involuntary. Ano po ba yung mga voluntary, involuntary? Pag voluntary, yung gusto nyo, benta ko sa iyo itong lupa. Ano yung involuntary? Example po namang involuntary, let's say hindi ka nakabayad ng $1 milyar, lumipas ang habang panahon, nag-post na sa newspaper, nagulat ka, uy, ando na pala yung lupa ako sa newspaper, nakalagay. Kasi delinquent kayo sa tax, yung realty tax na tinatawag. Ano pong gagawin ng gobyerno? Let's say ng City Hall of Quezon City, i-auction. So pag na-auction, bibilhin ng highest bidder, tapos after 1 year, hindi mo nakuha, malilipat na yung titulo sa buyer. Or paano kung within 1 year, nalaman mo, uy, nabenta, ang utang ko pala is 150,000 lang na tax, tapos ang value ng lupa ko, 10 million. Anong gagawin dapat para mabawi? Dapat mo hong babayaran mo, bibilhin mo na. Mayroon ka hong 1 year within which to redeem, habulin pa. Pero after 1 year, hindi mo na habol, mape-perfect na yung titulo dun sa buyer. Sa iba ho, nakakaligtaan nila yon. That's why it's crucial to pay your real estate tax every year. Sabi mo, hindi naman ako, doon ako nakatira eh. Hindi ho enough yun. Yung possession is not enough to protect your rights over the property. pwede ho yung makuha ng gobyerno. Magiging involuntary sale po yun to the highest bidder. Next is donation. Let's say you have a property, gusto mong i-donate sa anak mo, that can be done by way of deed of donation. Another is by way of inheritance. Later on, we'll see kung ano po yung pinaka-best option if you want to transfer a property. Is it by way of sale, donation, or inheritance? Alin ba ang mas makakasave kayo? Inheritance po, matatransfer lang after death. Pwede bang ipamana habang buhay pa? Sa batas po natin, it's not allowed eh. Habang buhay ka, hindi mag-take effect yung inheritance. Ang pwedeng gawin lang is donation. Fourth is foreclosure, judicial or extrajudicial. Example po ng foreclosure, let's say sinangla sa bangko, hindi nabayaran, after several yung term na binigay sa inyo, hindi na pabayaran, pwede na hong ma-foreclose ng bangko yon. Again, pag na-foreclose, meron ka pa rin 1 year to redeem. After 1 year, hindi mo na-redeem, mape-perfect na po ang title sa pangalan ng bangko. 5 is dasyon in pago. Ano po ba yung dasyon in pago? Example, let's say, may utang kayo sa seatmate nyo, 10 million, sabi ng seatmate nyo, hindi ko na mabayaran ng cash, pwede bang ibayad ko na lang sa iyo yung aming house and lot? Pwede po ba yon? Yes, ang tawag po doon is yung dasyon in pago. Let's say may utang kang cellphone, hindi mo nabayaran, o pwedeng ibayad ko na lang sa iyo yung kotse ko. Ang mahal namang cellphone nun. Pero pwede po yon. Dasyon in pago ang tawag doon. Parang barter. Ito yung pambayad ko dun sa naging utang ko sa iyo. Dasyon in pago. Not by way of cash. So ito po yung iba't ibang klase ng pagta-transfer o pag-convey ng ownership ng land. Definition of dasyon in pago, it is the delivery and transmission of ownership of a thing by the debtor to the creditor as an accepted equivalent of the performance of the obligation. It's a mode of payment. Now, let's compare po pag gusto niyo mag-transfer. Yung with respect to taxes, ano ba yung pinakamatipid kung magta-tax tayo? Magta-transfer tayo ng property, let's say to transfer natin sa anak natin or sa ibang tao. First, let's consider po yung estate tax. Yung estate tax po, nangyayari, let's say, pag namatay ang parents natin, tapos may property, let's say land, tapos ililipat sa atin ngayon. Pwede bang malipat without paying the taxes? No. We have to pay the taxes first. Ito po yung table natin. So, consider na lang natin yung maximum. The maximum, kasi yung amount po nagbabary eh. Habang tumataas ang value ng property, ng estate, tumataas din. Maximum po dito, 20%. Let's say mayroon kang 100 million property. 10 million tayo. 100 million. So maximum ang exposure po doon is 20%. So kung 100 million, i-exclude na natin yung 1215, no? 100 million, i-fix lang natin sa 20 para madaling i-compute. Yung 100 million nating property, imagine ang ibabayad mo sa gobyerno is around 20 million. 20%. Sabi mo, binigay ko na lang sa CCF yun. Nandun pa yung pangalan ko sa isang pintuan. Donated by. So that's substantial. Imagine 100 million, 20 million will go to government by way of the estate tax. Estate tax. Now, ganun po yung sa estate tax. Kapag ang hintayin natin na, saka ako na lang ilipat to, pag namatay ako, bahala ng mga anak ko. Ano po yung problem pagka ganun ang nangyari? Ang problem ko minsan, hindi aware yung mga anak. Ano bang gagawin? Tapos nag-aaway-away pa. In fact, ang problem ngayon, ang dami mga estates, yung mga lupa, nakapangalan pa sa mga lolo-lola, hindi na ilipat. Ay pagka ganun po, hindi lang ito yung problema mo. May penalties pa po yun eh. Meaning for every year na hindi mo nabayaran, 50% ang surcharge. Let's say yung 20 million natin kanina, dapat due sa last year. By the way, within 6 months ho, dapat mabayaran siya after death. Paano kung hindi ko nabayaran? May penalty, surcharge na 50%. Let's say 20 million last year, ngayon ako magbabayad. So yung 20 million ko, may surcharge siya na 50%, magiging 30. Eh next year, hindi ko pa ulit binayaran. Yung 30 mo, plus 15, 45. Baka mamaya maubos yung value ng estates sa taxes pa lang. Sa taxes pa lang. So, that's with respect to inheritance. Next po, paano kung donation naman? Buhay ka pa, gusto mong ibigay na, i-transfer to your son or to your children. Ito po yung table. Ano maximum po dito is 15%. So let's use yung ating example. 100 million property. Pag pina-inherit mo by way of inheritance, let's say extra, by way of last will and testament, maximum na 20 million. Pero pag dinonate mo, ngayon pa lang, maximum of 15. So kung 100 million, ang exposure mo lang is 15 million. Nakatipid ka ng 5 million. So yun po yung difference. Pag donation, tipid ka ng 5% maximum. We're just using the maximum percentage na po. Tapos pagka by way of inheritance, estate, 20%. So between the two, kung pipili ka, mas okay nang mag-donate ng property. Ayaw mo talaga magbayad ng tax. May way ba? I-donate mo. Meron po. Gamitin mo ito. Dito, 100,000 pala. 100,000. Ang value ng property ko is, let's say, 2 million. Paano? Pwede bang ganyan? Pwede. Anong gagawin ko? 2017, donate ako 2 million. I hereby donate 100,000 peso value of the property. So na-donate mo na. Next year, 100,000 ulit. Hanggang maubos ang iyong 2 million. Hindi ka nagbayad ng tax by way of donation. I-annotate ng pero ang dami hong annotation sa likod ng titulo yun. Imagine, 20 times na annotation. Ang dami nung entries nito. Tapos ibibenta mo, ba't ang daming 20? Ba't 20 entries yan doon sa likod? Pag nakikita ko kayo ng titulo, di ba may sa likod may encumbrances? I-annotate doon yung donation. Pet malo talaga ang magulang mo. Malupit. Lodi talaga. Kasi 20 entries. Pero pwede kong gawin yon if you want to avoid taxes by way of donation. Alright. Now, compare po natin. Comparison. By the way, yung sale, pag binenta, ano ba yung tax? Pag nagbenta tayo, binenta ko sa yung lupa, how much? What's the percentage? Capital gains? 6%. So imagine po yun natin yung tatlong option, ano? If it is by way of inheritance, pamana natin, maximum of 20. Pag dinonate natin, maximum of 15. Pag binenta natin, 6% lang. So among the three, the best option is by way of sale. Benta na lang natin. Tingnan niyo yung difference. Assuming na 100,000 yung tax exposure natin, max lang, assuming 100 million. Pag ginawa natin by way of inheritance, imagine 100 million yung tax. Pag naman dinonate natin, yung tax natin will be lowered by 75. Pero ang pinakamababa talaga is by way of sale. Kung 100 million yung tax kapag by way of inheritance, pag sale yan, ang exposure mo is around 30 million lang. So kung yung tatlong pagpipilian nyo, gusto nyo i-transfer na yung property, ibenta nyo na lang by way of sale. Paano kung halimbawa ngayon, bebenta ko sa anak ko, pwede ba yun? Before medyo mahirap kasi hahanapan ng BIR ng capacity to pay si buyer. Pero ngayon hindi na ini-examine eh. Ang nire-require lang is affidavit that you receive the money, notarized, acknowledgement, receipt ng payment. Lagay mo doon, na-receive ko sa anak ko yung pinagbenta, yung binenta ko, ang lupa ko sa Valle Verde around 50 million, enough na yon. Tapos 50 million times 6. 3 million ang capital gains mo lang. Nalipat na sa anak mo. Imagine ang laki ng na-save mo nun. Kung 50 million at 20% max, mga around 10 million ang tax nun. Ikaw ba magbabayad nun? Of course, wala ka na. Burden nung naiwan ng mga anak. Ano ang problem pagka ang laki ng property tapos hindi magkasundo yung mga anak? Nag-aaway-away. Hindi lang yung tax ang naging problema. Kukuha ng abogado kasi ang laki ng property, tapos sasabihin ng abogado, ano bang value ng estate nyo? Around 1 billion. O sige, okay na. We'll accept it at 5% success fee. Plus appearance of 10,000 every hearing. It will take 30 years. Mauubos yung sa kaka-appear. Pagdating sa korte, sabihin, good morning, Your Honor, respectfully appearing for the heirs. Noted, the hearing is cancelled, reset 2. Tapos, attorney, tapos na yung hearing, tapos na. Bayad na ako ng 10,000 sa iyo. Oo, yun lang sinabi nyo. 10,000 na. That's why, as much as possible, avoid going to court. It's not beneficial. The best way is to settle, especially if it is a family issue. Discuss, settle, and compromise. All right. Now, next item is MA, avoidance of error. Pag magtatransact tayo sa lupa, ano yung mga errors that we should avoid para hindi tayo maging victim ng fraudulent transactions? So these are the errors that we should avoid if we will be involved or engage in the in land transaction. First, avoid fraudulent transaction. Yung mga transaction na kaduda-duda or may fraud. Second, avoid double sale. One title, binenta sa dalawang tao. Pwede mo mangyari yun? Yes, it's possible. Third, avoid fake land titles. Fourth, avoid also yung buying lost title. Nawala yung titulo, pero may titulo yan, benta ko sa'yo. Avoid doing that as well. Fifth, forgeries. Avoid forgeries. And then sixth, yung double title. One property, dalawang titulo na clone. Okay, let's start with avoiding fraudulent transactions. How can we avoid fraudulent transactions? Yung tinatawag, one, by way of yung backtracking. Paano po ba yung backtracking? Yung babalikan mo. Let's say yung titulong binibili mo is title number 3, TCT na. Pag TCT ho, ibig sabihin may pinanggalingan na. Ano yung original title na tinatawag? Pag original po, OCT, Original Certificate of Title. Let's say OCT 1. Pag yung OCT 1, let's say nasa akin naka-issue, bibenta ko sa'yo, you will not receive OCT 1. What you will receive is TCT, let's say 1, Transfer Certificate of Title number 1, registered in your name. Pag binenta mo kay third person, yung titulo niya is magiging TCT number 2. Ngayon, pag tayo yung buyer ng TCT number 2, gusto natin makasigurado, i-check natin backward. Saan ba galing yung titulo mo? TCT 1. Check ko kung tama din na meron talagang TCT 1. Pabalik ho. Yun ho yung makakasigurado kayo. Ano ang risk pag hindi natin binacktrack? May problem kasi na yung iba, pinipeke. Halimbawa, yung para makasave ng taxes. Let's say, yung title OCT pala, patay na, binuhay lang. Pwede ba yon? Pwede ho. Ganito. Let's say, yung sa parents ko, yung title nakarehistro pa sa kanila. Spouses, let's say, title number 1, registered in the name of spouses Samarita, ay patay na. Ngayon gusto ko makatipid kasi mga 20 years na silang patay. Ibibenta ko sa inyo. Para hindi ako magbayad ng estate tax, anong gagawin ko? Deed of, ang pinakamatipid, di ba, is deed of absolute sale. Bubuhayin ko yung parents ko. Spouses, deed of absolute sale between spouses Samarita and Mrs. Shimamoto. Ngayon, pipirma din yung parents ko. Nakapirma doon. Dinotarize din. So, pagpunta ko sa BIR, tatanungin ba ng BIR, asan ba si Mr. and Miss Samarita? Buhay pa ba yun? Hindi naman tinatanong eh. Sir, itong pambayad ko, itong manager's check, bayad ka sa bangko, pag nakabayad na ako ng tax, bibigyan ako ng car, pagkakuha ko ng car, pwede nang punta ng RD, ililipat na sa pangalan ni Mrs. Shimamoto. Ngayon, ibibenta ni Mrs. Shimamoto, let's say sa inyo po. Ngayon, pagka napunta na sa inyo, tapos nagkaroon ng examination sa BIR, nakita nila, ay, asaan ang car noong previous? Kasi patay na tong sila Samarita. Pag pinunta sa BIR, walang car. Kasi ang ginawa nila, binuhay. Sino ho mananagot ngayon doon sa taxes? Sa inyo na ho yun. Ibig sabihin, hindi malilipat papunta sa pangalan nyo yung titulo hanggat hindi nasisettle lahat ng taxes. Sabi nyo, wala akong alam doon ah. Hindi ho excuse yung hindi nyo alam. Kaya kailangan siyang i-backtrack. Kay RD, yung sa LRA, hindi yan LAR, it's LRA, Land Registration Authority. Ano po yung importansya ng Land Registration Authority? Sa LRA ho, doon makikita kung totoo yung titulo, kung yan ay talagang private, at kung tama yung sukat. LRA. Sa RD po, Register of Deeds, doon naman po natin makukuha yung listahan ng mga totoong titulo. Ngayon, mas madali yung malaman kung totoo o peke ang titulo kasi computerized na. Pag hingi kayo ng certified copy, unlike before, tinatatakan lang ho, di ba? Certified copy na yan, okay na. Ngayon, hindi na ho ganon. Electronic na. Kaya mas madaling malaman kung fake o original kasi pag nakakuha kayo ng electronic copy, you can rely on that. Kasi isa lang dapat yon kasi computerized na ho ngayon eh. Hindi, na-avoid na ho yung issuance ng double or triple title. Remember before yung mga practice na, kailangan ko mag-abroad. Anong hingi ng US Embassy? Kailangan ko daw mag-produce ng land title? Madali lang yan. Samahan kita sa kaibigan kong RD. Ilang bang hektarya ang kailangan mo? Siguro mga 10 hectares. Okay lang yan. Anong ginagawa ho nila? Kukuha ng, kasi tinatype lang dati ang titulo, di ba? O, title number 1. Kanino ba nakapangalan yan? Kay Mr. and Mrs. Shimamoto. O sige, gawa tayo ng Mr. and Mrs. De La Cruz. Ayan na. So yung title number 1, dalawa ang titulo. Isa yung kay Mrs. Shimamoto at saka isa yung na-issue sa atin ngayon. Gagamitin ko lang naman to sa pag-abroad, hindi naman talaga totoo. Kaya pwede hong mangyari dati. Ngayon hindi na ho pwede yon kasi nga computerized na siya. Assessor BIR. Backtracking. Sa BIR, basically, makakukuha kayo dito nung CAR na tinatawag, yung Certificate Authorizing Registration, na ibig sabihin, nabayaran na yung taxes bago malipat yung titulo. Next, check the meets and bounds. Yung pong measurement. Geodetic engineer usually ang nakakapag-check niyan. Probably narinig yung sinasabi na hindi nagsarado yung survey. Pag hindi yung nagsarado, ibig sabihin may defects sa survey. Kasi hindi nagsarado yung measurement. May opening. Ano yung usual na problem pagka hindi natin na-check ang meets and bounds, yung technical description? Yung problem ho ng overlapping, na nag-encroach ka daw, paano kung nagtayo ka ng mansion mo tapos nag-encroach ka ng 10 meters, tapos ikaw yung napatunayan na bad faith, ano mangyayari? Kailangang igibain, i-destroy yung pinatayo mo, bayad ka pa. Destroy na, you have to pay for damages pa. That's why it's crucial for you to check the meets and bounds, yung technical description ng property. Next, actual possession. Pag bibili ka ng property, check kung sino yung nasa actual possession. Do not just rely on the title. Let's say, may property ako dyan, vacant lang yon. Tapos naniwala ka, binili mo, tapos pagpunta mo doon, may nakatayo na palang bahay, siya yung nasa possession. Can you just say na, uy, alis ka dyan, ako yung real property owner? Of course not. It's not that easy. Baka mamaya, kung talaga ikaw yung nakabili, tapos tamang owner ka, you have to go to court, file a case for ejectment or unlawful detainer. Mas problematic pa. So check the actual possession, kung sino yung namumosisyon dun sa lupa. Next, check the identity of the owner. Kung talagang buhay pa siya o hindi. Especially kung naka-SPA lang. Pwede mong bumili ng lupa na naka-SPA lang yung nagbebenta in behalf of the owner. Pwede naman po, pero make sure na chinek mo talaga yung real owner. Kasi yung SPA po, kasi ginagawa naman talaga yon. Halimbawa, nasa US, ano ba ang risk kapag ka naka-SPA lang? Pagkapatay na yung nag-issue ng SPA. Bakit hindi na ho ba valid ang SPA na namatay na yung nagbigay? Hindi ho. The moment na namatay, patay na rin si SPA. So check the identity of the owner kung buhay at kung talagang siya ang real owner ng property. And then the last one, last two. Authority of person if based on SPA. Kasi yung SPA, nakalagay dyan, kung ano lang yung authority. Nakalagay lang pala doon is to manage, to look for buyers, tapos wala naman nakalagay na to sign, sell, execute documents, and to receive payment. Binigyan yung pera, umasa kayo doon sa SPA na may authority to sign, ngayon nagbayad ka. Tapos pagdating sa RD, sabi niya, ay ma'am, hindi ho valid to. Sa BIR, kasi kwan lang to, authority to manage, wala hong authority to sell, to receive, to sign. So, make sure na may authority yung person who is selling the property based on SPA. Then the sixth is the authenticity of the title and the encumbrances. Authenticity of the title. Paano ho mati-check kung authentic ang title? Do not just rely, mukha namang totoo to. Mukhang hindi galing sa recto kasi may kulay-kulay pa. Do not just rely on the title. Go to the RD and check. Better yet, hingi kayo ng electronic copy sa RD so that you can check the authenticity of that title. Encumbrances, yung sa likod po, check nyo din yung encumbrances. Kasi meron po mga encumbrances yan. Example, yung mga limitations. Let's say you will buy a property in Valle Verde. Can you just put a house and lot na 5-story? Of course not, kasi may mga tinatawag pong restrictions na eto lang ang pwede mong itayo. Just like, if you're familiar dun po sa kanto ng Ortigas and EDSA, yung may flyover, ito yung POAA. Sa tapat ng POAA, may bakanting hukay na mga 30 years na. Hindi pa pinapanganak ang anak ko. hukay na siya. Pero hanggang ngayon walang ginagawa. May kaso po kasi siya. Binili nila yon to put up a tall, parang 70-story building. Meron ng restriction kasi yung sa Green Hills East. Hindi ka pwedeng magtayo. Di ba yung pag nasa EDSA kayo, mabababa lang yung building? Simula sa may Caltex ba yun, Petron? Yung street ng, what street is that? Going to Green Hills. No, EDSA, if you're going to Makati, nasa right side. Not Wilson. Annapolis? No. Yung sa after Subel. Hindi, not Subel. After, basta yung simula Krame, makikita nyo, di ba, mabababa lang yung building. Why? Because there are restrictions. So if you're going to buy a property, check yung mga limitation encumbrances. Okay, so these are the means of avoiding fraudulent transactions involving land. Now, let's consider the rules on double sale. The first registrant in good faith. Yung first po na nagrehistro. Now, kung walang nagparehistro, ang rule will be the first possessor in good faith. The rule on double title is that the general rule is that where two certificates of title are issued to different persons covering the same land in whole or in part, the earlier in date must prevail as between the original parties. And in case of successive registration where more than one certificate is issued over the land, the person holding under the prior certificate is entitled to the land as against the person who relies on the second certificate. Now, forgeries, yung namemeke. Let's say, pineke yung deed of sale, nabili mo. What will happen? Ito po yung rule. Generally, a forged or fraudulent deed is a nullity and conveys no title. A fraudulent or forged document of sale may become the root of valid title if the certificate of title has already been transferred from the name of the true owner to the name of the forger or the name indicated by the forger, and while it remained that way, the land was subsequently sold to an innocent purchaser. Example po, let's say, ako yung real owner, registered owner of the property, binenta ko kay ma'am, tapos pineke lang yung signature ko. Nalipat ngayon yung titulo sa kanya. Hindi ko pa alam. Tapos ngayon, pagkalipat sa kanya, binenta niya kay sir. Si sir hindi niya alam na pineke lang yung signature ko. Pero yung transaction nila, valid, yung signature, okay, nasa na kanya na ngayon yung property, nalipat. Na-discover ko ngayon, oy, ba't iba na nakatira dun sa may bahay na? Yung lupa ko, pinalatayuan ng mansyon, yung lupa ko dating bakante. Pinuntahan ko, sir, lupa ko yan Ay, hindi ho, nabili ko na to kay ma'am. Pwede ko pa bang habulin kay sir? Hindi na. Ano yung remedy ko? Habulin ko siya. Paano kung walang pera, talagang mamimeke lang, manggagancho lang. Example lang, mama, not you. Ano yung remedy ko? To file a case against her. Pero paano kung wala na? Sorry na lang. Anyway, there's one remedy na pwedeng gawin kung talagang walang-wala na, naging victim kayo ng manggagancho. Later on, we'll have that here as the remedy. Now, remedies. The aggrieved party has a number of remedies to quench the validity of judgment in registration case. Now, ito po yung pagrehistro. Pag nagparehistro ng lupa, may decision ng court, pwede nyo pang questionin yung decision ng court kung kayo yung naging victim ng fraudulent transaction or fraudulent registration. What are the remedies? Number one, although these are technical, enumerate ko na lang po. One is motion for reconsideration or new trial kung naging decision ng korte is against you with respect to the registration of your property. Number two, petition for relief from judgment. These are court remedies, legal remedies. Number three is an appeal from that decision. Fourth is petition for review of the decree of registration. And then fifth is action for reconveyance. Yung reconveyance po, para maibalik yung titulo, petition for review of the registration, you have certiorari as an example, appeal from the decision, petition. Now, another remedy is a new trial or reconsideration. Ang crucial lang ho dito yung period. Let's say, 15 days, nagkaroon ng desisyon tungkol sa registration ng lupa, tapos yung decision is not favorable sa inyo, what you can do is to file a motion for new trial or reconsideration. Paano kung nakaligtaan? Kasi yung lawyer nyo, let's say, hindi taga CCF, nakalimutan. May option pa rin. Kasi tapos na, let's say 16th day nyo nalaman, ang option is relief from judgment. when a judgment or final order is entered or any proceeding is thereafter taken against a party in any court through fraud, meron lang hong ground, yung FAME na tinatawag, fraud, accident, mistake, or excusable negligence. You have 60 days to file. So 15 days, hindi mo nagawa, meron ka pa ring option. Relief from judgment, 60 days after na ma-approve yung registration ng lupa. Now, kung nakaligtaan, kasi hindi nakapag-file, meron pa hong option din, yung appeal from the decision of the court, land registration court. And then fourth remedy, review of decree of registration. Ito, kung nakaligtaan, 15 days hindi gumawa ng action, tapos 60 days, hindi pa rin. So meron ka pa rin, halimbawa, last year, December, nagkaroon ng decision, you have 1 year from December of last year until December of this year within which to do an action which is review of the decree of registration. Now, illustrative case, Republic versus Losada. Ito po, yung case ng mag-asawang si Losada, nagparehistro sila ng lupa. Ang unang nag-try na magparehistro ay yung husband niya, na-deny yung application. Tapos, ang ginawa nila, instead na yung husband mag-appeal, yung wife ang ginamit niya, sige, apply ka ulit. Pero may fraud. Ito yung ginawa, sabi ng korte, may fraud kasi the wife did not disclose that her husband's previous application was denied because the land is reserved for school site. So, hindi nila sinabi yun doon sa kanilang application sa pagparehistro ng lupa. And then second, in concealing the lands were of public domain. Yung public domain ho, ibig sabihin, hindi parang pag-aari ng gobyerno, ng state, hindi pwedeng i-privatize. One example of a big land case, if you're familiar with the Calatagan Estate in Batangas, it involves around mga 3,000 hectares. It used to be owned by the Ayala Isia, Spanish time. Tapos ang ginawa nila, they sold the property around 2,000 hectares to Lusyutan's group. Ngayon, nag-file ang government, no, hindi nyo pwedeng pagbentahan yan kasi public domain yan, public land. The government filed an action, tapos napawalang bisa yung titulo. Around 1988, nagkaroon ng Supreme Court decision. Pero until now, if you will go to Calatagan and check the property, sinong nakatayo doon? The Lusyutan group. Hindi mo pwedeng kunin kasi ang daming guards. It's a protected, may decision pero hindi ma-implement. They are still in control of that public land. And then third, in stating deliberately falsehood that the lands were inherited from her father. So ito, kasi pag public domain, hindi mo pwedeng ipamana. And then fourth, the filing of the application in her name only, excluding her husband. So may fraud kasi instant na isama niya yung husband niya, yung pangalan na lang niya. Kasi pag sinama niya yung husband niya, meron ng decision previously hindi nga sila pinayagang i-rehistro yung lupa. So dito po, sabi ng court, kahit na nag-lapse yung period within which to question, pwede ba because there was fraud. There was fraud. So pagka naging victim kayo ng fraud, kahit na nakaligtaan nyo yung halimbawa, ay tapos na, 15 days, pwede nyo pa hong i-question yon. Now, action for a conveyance. Yung action for a conveyance po, para maibalik naman yung titulo kung nalipat sa iba. It is a legal remedy granted to the rightful owner of land which has been wrongfully or erroneously registered in the name of another for the purpose of compelling the latter to transfer or reconvey the land to him. Para mabalik po sa inyo. Action for a conveyance po ang tawag doon. Next. What will happen if the title was already transferred using forged signature? Ito po yung rule. Kung yung unang transaction, null and void, walang bisa po. Pag unang transaction. Pero pag na-transfer na yan, when they're showing the property, simply held in trust, no, hindi, ito po yung concept, no? Let's say, titulo ko, napunta sa kanya, pineke ang signature ko, tapos yung title presently nasa pangalan niya. Ano yung status ng titulo niya? Legally, parang naka-entrust lang sa kanya. Sorry. Naka-entrust lang sa kanya. Parang pinagkatiwala lang. Pwede ba niyang ibenta? Pwede, pero kung alam ng buyer na mayroong fraudulent transaction, hindi siya innocent purchaser. Paano kung hindi niya alam, tapos nabili niya, nalipat pa sa kanya? It will ripen into a valid title, perfect title na. Kasi hindi niya alam na may fraud. So anong gagawin ko dapat para maprotektahan? Ay naghahabol pa ako sa kanya. before na mag-file ako ng case para lang hindi mabenta, anong dapat kong gawin? Meron nung tinatawag na adverse claim. You don't need to go to court, punta ka lang sa RD, ipa-annotate yung adverse claim para hindi mailipat ang lupa sa pangalan ng ibang tao. Now, remedies. Kung naging victim kayo, these are additional remedies, action for damages. Let's say yung kanina po, paano kung napunta na sa ibang tao yung lupa, tapos hinahabol ko siya, hindi ko na mahabol yung nakabili. Pwede ako mag-file ng action laban sa kanya asking for damages, daños perjuicio. Seventh, action against the assurance fund. Yung kanina hong situation, paano kung wala na siya? Talagang naloko lang ako, manggagadso, walang pera, wala kang kapera-perang pang-file or maibayad sa lawyer para i-protect yung right niya. Pwede ho tayong mag-file against the assurance fund. Ito po yung parang yung government natin, meron siyang fund na pag yung mga registered owners naging biktima ng fraudulent transaction, tapos hindi na niya na ma-recover yung property, pwede ko mag-apply sa assurance fund. Babayaran po yan. It is filed against the Treasurer of the Republic. Kung hindi na kayo makarecover ng lupa nyo, yung kabayaran na lang. Pero yung amount po niyan, kasi gobyerno yan, you will not be able to get the parang market value of your property. Mababa lang po yan. Parang yung mga nag-road widening, tapos yung property nyo nakunan, yung value niya, hindi ko makadictate kung ano yung amount na gusto. Sila yung magsasabi ng amount na ibabayad sa inyo. Yun lang ho ang disadvantage kapag ito yung option na kinuha nyo. Number 8, quieting of title. Yung quieting of title po, hindi ibig sabihin patahimikin nyo yung titulo. It's more of quieting of title. Kung may doubt, parang aalisin yung duda sa titulo nyo. Ipa-file nyo sa court para maging walang duda ang pag-aari or pagmamayari nyo ng titulo ng lupa. 9, cancellation involving double title. Yung kanina po, di ba, dalawang title. Let's say Title 1, Title 2, referring to the same property. So dapat dun sa dalawang titulo na yun, mapakancel yung isa para isa lang talaga maging valid title. Para mangyari yon, you have to file an action for cancellation of a title. Yung fraudulent title na na-issue ang mapapakancel. Last one, action for reversion. Yung action for reversion po, ito yung para maibalik yung lupang napunta sa iba. Maibalik. So basically, those are the remedies. Now, action for damages, we're done with that. Assurance fund, quieting of title, cancellation of title, action for reversion, other remedies and defenses for your protection. Yung purchaser in good faith po, bumili ka ng lupa, tapos hindi mo alam na mayroong fraud na nangyari in the past, you are a purchaser in good faith, pwede mong you can validly own that land. Yung example po natin kanina, ako yung may-ari, nabenta sa kanya, pero pinake yung aking signature between the two of us, null and void yung transaction. Pero pag siya, nabenta niya sa iba, hindi ko alam, yung buyer po is a buyer in good faith. Pwede ko pang habulin sa buyer in good faith? Hindi na. Perfected na yung title dun sa pangatlong person. Next, latches. Yung latches po, yung pagkatapos ng mahabang panahon, wala akong ginawa, ako yung owner, napunta na sa iba, tapos hindi ko ako gumawa ng action, pwede na maging perfect yung title sa ibang tao. Parang yung latches po, natulog ka sa iyong karapatan, tinulugan mo ang iyong right. Next, notice list pendants. Ano po ang notice list pendants? Halimbawa, mayroong kaso tayo, para yung lupa hindi mapunta sa iba, papalagyan natin sa likod ng annotation na mayroong pending case. Ano po ang effect nun? Ang effect kasi kung ako yung buyer, tapos makikita ko doon sa titulo, ay meron palang pending case to. Hindi ko bibilhin yon. Bakit? Ano ang mangyayari pag despite na notice na may list pendants, binili ko pa rin, kung ano ang maging epekto ng decision doon, magiging binding sa akin. And usually, buyers will not get a property na merong notice list pendants. Yung may encumbrance po or may notice sa likod ng titulo. And then adverse claim, yung kanina po, pinapa-annotate natin sa titulo. Other concerns, land under co-ownership. Paano kung dalawa tayong may-ari tapos gusto ko nang ibenta? Pwede bang mabenta ng yung kalahati na mayroong pag-technical description? Of course not. Hindi po pwede kasi co-ownership, parang walang specific meets and bounds pa yan. So kailangan mong kunin yung consent or ipa-resurvey nyo, hatiin, tapos saka mo ibenta. Yung co-ownership, usually yung mga properties na ang titulo nakapangalan sa 2 or 3 tao. Kahit man may nakalagay na kuminsan parang proportion, 1/2 to A, 1/4 to B, 1/4 to C. Sabi ni C, benta ko sa iba yung aking kay D, yung share ko. That cannot be done without the consent of the other co-owners. Paano kung benta ko na lang sa isang co-owner? Pwede bang ibenta sa isang co-owner? Mas okay yun, mas preferred. Kasi pwedeng mag-consolidate yung ownership sa isang tao na lang. Now, death of registered owner. Paano masisettle yung death ng registered owner? Pwede bang mabenta? Let's say namatay ng parents natin, gusto nating ibenta, diretso. Pwede ba yon? Pwede ho. Ang mangyayari, isang dokumento lang, yung extrajudicial settlement with deed of absolute sale. Parang i-settle na natin plus diretsong bentahan. Pwede hong gawin yon para makasave kayo on documentation, lawyer's fees, etc. Land without titles. Paano kung naandun na, nakaposisyon tayo, tapos wala tayong titulo? This case, kung walang titulo yan, it's either tax deck lang ang hawak or yung rights. Paano kung tax deck po yung hawak nyo? Kailangan nyo pang ipa-convert siya into a title. Paano magpa-convert? Meron nung administrative at saka judicial processes. Apply kayo sa DNR kung administrative. Kung court naman, file kayo ng petition sa korte. Dalawang options po yung pwedeng gawin kapag tax deck. Sa probinsya, karamihan ng mga lupa nasa tax deck pa lang. Pagka ganon, pwedeng i-convert into a land title. Fifth, sale by one spouse only. Paano kung isang spouse, valid ba yung pag-sale ng isang property? Let's say family code na lang kasi iba yung civil code. Family code, nagbenta yung asawa nyo, hindi nyo alam. Valid ho ba yun? Hindi. Sa family code unless may complete separation ng property po. Pero ang general rule kasi sa atin, pag family, nag-asawa ka, tapos wala kayong prenup agreement, lahat ng properties mo, property na rin ng asawa mo. Paano kung nagbenta yung asawa mo, kahit pa namana niya, yung daladala niya, let's say, nag-asawa ka, 1 peso lang yung value mo, yung asawa mo, 100 million. Tapos nung nag-asawa na kayo, sabi ng asawa, total, ako naman may-ari nito, ibenta ko na lang without your consent. Binenta niya. Pwede pa bang habulan yon? Pwede pa ho. Kasi yung kahit na sabihin na property niya nung pagkadalaga, sa family code ho kasi absolute community of property without prenup, pwedeng habulan yung binenta ng isang asawa lang. Kaya nga ho, pag naglo-loan kayo sa bangko or may transaction kayo, kahit na isang asawa lang pumupunta, anong ginagawa ng bangko or ng ibang entities? With the consent of or with the conformity of. Kahit na matagal na, 10 taon na kami maghiwalay, wala siyang pakialam. Ako nagdugot pawis ko ang pagbili ng lupa or kondong ito. Kailangan ko pang kunin yung consent niya? Yes. Kailangan ho na yun yung rule. That's why kung magbebenta kayo or bibili kayo, kung may asawa ka, bibili ka ng property, hiwalay ka sa asawa, what should you do? Hindi ho, kahit pangalan mo sa sarili mo, it will not. It's not valid. Ka-share pa rin siya. Kahit na 20 years na kami maghiwalay, tapos bumili ako ng 100 million property, half of it or may share pa rin siya? Yes, yun ho kasi yung rule. So anong best option? Reconcile. Now, land under co-ownership, okay, that's the death of registered owner. Paano kung namatay na yung may-ari ng lupa? Anong dapat hong gawin? Estate has to be settled either judicially or extrajudicially. Judicial settlement, mag-file kayo sa korte. Yung extrajudicial, kung nag-agree lahat ng mga tagapagmana, perma na lang kayo ng extrajudicial settlement. Mas kwan ho yan, mas mabilis, mas mura, mas madaling gawin, rather than to go to court. No title or tax deck, we had that earlier. Dalawa yung option, admin proceedings or judicial proceedings. Then the last one, K, knowing the best possession. What's the best possession to have? Land ba or condo? Land ba or condo? Anyway, I'm not referring to the earthly things. For the Bible says, Mark 8:36, for what shall it profit a man if he shall gain the whole world and lose his own soul? Parang if we're thinking of condo or land, and replace this, for what shall it profit a man if he shall gain the condo and the land in this world? If you gain because Attorney Doy is from Mega World, imagine if you own the whole of Mega World, but lose your soul. So between having your soul and having properties in this world, according to this verse, which is more important? Preserve your soul. Hindi naman po exclusive to. Parang sinasabi lang niya, kung papipiliin ka na maging exclusive, choose the better option. Choose the better option.